Welcome back, everyone. It's the lawyer you know, and today we're going to be reacting to Mark Richards' interviews, the lead defense attorney for Kyle Rittenhouse. We did Binger, the prosecutor, last week, and we've got a lot of suggestions to also talk about what Mark Richards said, what he thought throughout the trial, what their strategy was, and what's going on now with Kyle Rittenhouse and their defense team. And to give just a quick outline of what we're going to be breaking down, because the first interview and the main interview we're talking about happened right after the trial. I think he was still at the courthouse. And then there was some subsequent interviews and then a longer form podcast. A lot of them contain the same content, but we'll be picking parts to talk about that we find interesting and that I think will answer a lot of the questions you all had throughout the trial as we spoke together on the lives. And just some of the highlights and a quick outline of what we're going to be talking about is Richard's feelings on the previous two lawyers that represented Kyle Rittenhouse before he got there with his co-counsel, what he was afraid of throughout the trial. He takes some shots at Binger, of course. We knew those were coming. He talks about Judge Schroeder and how he feels about him. Also talks about the actions of Kyle Rittenhouse and whether or not he agrees with them. Because he makes clear throughout all his interviews, he is not a political lawyer. He's there to represent a client, not a cause. And then we're also going to talk about what he thought of this jury. And lastly, we're going to talk a little bit about money. Where they got the money in this case, whether or not he was paid or was it just publicity, whether or not the experts and jury consultants and everybody was paid on this case, or was it all just publicity? Were they all just trying to get involved because they knew this was going to be a big case? So if you like our reactions to interviews and you want us to do more in the future, please subscribe to our page and like this video so that we know what content you like best. So as I mentioned, this was directly after the trial ended, and he even said, we haven't had a chance to process this fully yet, but I've listened to some other interviews and he's consistent with kind of his thoughts throughout the trial. And some of those main thoughts start with the two lawyers, Woods and Pierce, that were on this case before that had to pro hoc vice in, which means have another lawyer from the actual state where the case is being tried sign off that you're a lawyer in good standing and you can handle this case. And while Mark Richards said he agreed to join the defense team and try the case, he did not agree to be their local counsel because he didn't necessarily think they were right for the case because they didn't have any criminal defense experience trying cases like this.
You know, when I took this case, I was hired by the two first lawyers. I'm not going to use their names. They wanted to use Kyle for a cause and something that I think was inappropriate. And I don't represent causes, I represent clients. And the only thing that ended up mattering to me was whether he was found not guilty or not. I believe that's what he wanted. And I told him when I first met him, when he was in custody, that if he was looking for somebody to go off on a crusade, I wasn't his lawyer.
He also told Kyle Rittenhouse and those lawyers that if they were looking for someone to rep a cause, people like those lawyers may have been doing, they were those kind of lawyers. He said, I'm not that kind of lawyer. I represent this client. I'm a criminal defense lawyer. That's what I'll do if that's what you need me for, but I'm not going to be out there for a crusade. And Kyle obviously agreed with that because he ended up firing those other lawyers. He also said that when he was asked, what do you feel one of the major turning points was in this case? And he said, getting those two lawyers off the case. He talked to them and said, do you want to represent this client or do you want to be out there raising money? Because apparently they were out there raising a ton of money for Kyle's defense, for legal fees and for expert fees. And a lot of that is bubbling up right now. And we'll talk about that more at the end, what's happening with the money. So when he took over the case on his own, he brought in what he calls his best friend, Corey.
And I got my best friend, Corey, to join, who I trust. And to be able to work with somebody who you don't have to check their work, you don't worry about what they're going to be doing, you give them a project and it's done as good or better as you do yourself, it's priceless.
To be his co-counsel, not associate counsel. Corey asked, how are we getting paid? He said, what am I going to get paid? And he said, the same as me, we bill the same amount, and we'll talk about whether or not they were paid later on in the video. What was he afraid of? So throughout these interviews, he talked about a couple things that scared him. One was the amount of death threats that he got was crazy in this case.
To me, it's scary how many death threats we've had. You know, I was answering my phone on the way back from court in Kenosha. My office isn't that far. After the third death threat, I quit answering the phone.
Two while the lesser includeds were being instructed to the jury and questioned Kyle about, he was afraid they were going to compromise him.
I was afraid of a compromise. I know it's been reported that we asked for lesser includeds. We objected to all lesser includeds. Kyle was questioned on lesser includeds because he has to be, but that wasn't our wish. That wasn't Kyle's wish. And we, as time went on, were afraid that there would be some horse trading in the jury room. And that's what really concerned us.
We talked about this a lot throughout the trial. Were they going to split the baby? Were they going to pick the gun charge or a lesser included? Gun charge went away. They didn't end up picking any of the lesser included. And lastly, he said this is the longest a jury has ever been out in a trial in his career.
I've never seen a jury, and I don't mean this as a slight to them, but they didn't have a lot of questions. We had no information that they ever fought. They were just working through the issues. And, so it was the time that made me nervous. There wasn't any information coming out.
And any of you think that shows that he's a bad lawyer, inexperienced, or anything like that is just wrong. Trial lawyers always get some nerves while the jury is out deliberating. No matter how great you feel about your case, no matter how strong you think your presentation was, it's always a bit nerve-wracking when you try a case and you put it in the hands of the jury. So here's something everybody wants to know. Did he take some shots at Binger?
I was a prosecutor. Corey was a prosecutor. And I never went after somebody like they did.
He and Corey, his co-counsel, were both prosecutors and criminal defense lawyers, so they know how this works. They know what it's like to be on the other side, and never did they go after a criminal defendant the way that Binger went after Kyle Rittenhouse. They said they were supposed to be, the prosecutors were supposed to be seeking truth, not putting liars on the stand. And he knew the Car Source brothers were lying on the stand. The FBI agents and law enforcement officers that questioned them even said they were lying, but the prosecutor knew that because of a rule of evidence, those law enforcement officers weren't going to be allowed to take the stand and say that those brothers were lying. Therefore, the prosecutor could put them on the stand, let them testify and lie, and they wouldn't be called out for those lies except for some inconsistent statements. The law enforcement officers would not be allowed to comment on their testimony because one witness is not allowed to comment on whether or not another witness is lying, even in this situation.
To put those guys on, Detective Howard and Detective Antaramian had both interviewed them, and in their police reports said, "We know you're lying." I can't ask that question when they're on the witness stand of the detective because one witness can't comment on another. So they put them on. They knew they were lying, and that's garbage.
So he thought it was horribly wrong that Binger did that and a few other things that Binger tried to pull throughout the case, like the drone footage and some of the video footage that was enhanced and not provided to them prior to this trial. And then to try to say that they stipulated to this when they didn't, because this was a different quality of video. And one of the reasons they stipulated to that video was because of the poor quality. They couldn't really see anything that happened, and they didn't think the jury could either. And the timing of when the video started was different as well. So he was not happy with how Binger handled a couple of those scenarios. He also said that a prosecutor is supposed to seek truth and justice, not to just win the case, and that was problematic for Binger in this case.
Justice is done when the truth is reached, and I don't know that it's set up to do that, but a prosecutor is supposed to seek the truth. It's not about winning, and this case became about winning, and that's probably why it got so personal.
He also said he knew Binger in his former life as a civil lawyer, kind of compared it to how he was as a prosecutor. Earlier in the interview, Richards himself said, "I am a criminal defense lawyer. That's what I do." And in other videos, he said, virtually my entire practice, or 95%, is being a criminal defense lawyer, basically pointing out that this is what he does, this is what he focuses on, and this is what he's an expert at. Next, let's talk about how he talked about Judge Schroeder.
I've tried cases as a prosecutor 100 years ago in front of Judge Schroeder. I've tried cases as a defense lawyer, and him and I butted heads as a defense lawyer.
He talked about in another interview how in Wisconsin, he actually has the right, the defendant has the right to strike one judge without question, basically, and they could pick some other judge in the jurisdiction. So they could have struck Schroeder if they wanted to. And he said they didn't think any judge was going to be easy on Kyle if he got convicted. They thought he's getting life, no matter who the judge is. But with Schroeder, they knew they were going to get a fair trial because what Schroeder is known for is being a fair trial judge and a very harsh punisher as a judge.
So I'd rather have a fair trial. I thought he gave us a fair trial.
So like they said, they didn't care. Schroeder or anybody else was going to be tough. And he basically said, you don't want to get your client convicted in front of Schroeder because then it's bad. But as far as the trial goes, he's going to give you a fair trial. So that's kind of how he thought Schroeder did. He thought he did provide a fair trial, and he thought a couple of calls early on in the motions, in the hearings that they had, they said, okay, we made the right decision sticking with Schroeder and not going for this other judge who's known as being much harder on criminal defendants. He also commented on the system Schroeder has about not calling the complaining witnesses victims, and other lawyers have agreed with that. And he said that's just Schroeder's system, not just on this case, but every case, and his system of pulling juror names out of a hat basically to determine who's going to get struck. And he said 3 of those 6 that were struck, they were crushed because they thought they were 3 of their strongest jurors, but Kyle picked their names. So there's no way to say it was unfair. He thinks that's actually a decent system for striking jurors. And it keeps the jurors on their feet so they don't know who the alternate jurors are. A very interesting portion of this interview was when he talked about whether or not he agreed with Kyle's actions. He said,
You know, if we all would just mind our own business a little bit, I think we'd all be better off. And it's a hard lesson to learn, but...
And he was talking about the protesters, rioters, and people in Kyle's camp. He doesn't personally think people should be walking around with AR-15s. He said that even though he agreed with the curfew and that minors shouldn't carry guns, that he was clear that that statute did not apply to Kyle because he was 17 carrying an AR-15, and that is not what the legislative intent was.
You know, we knew from the beginning that if you read that statute correctly, I know everybody thought I was crazy. If you read the statute correctly, he was legal in having that firearm. And obviously once the evidence came in, the judge threw the charge. They threw the curfew. And those were things that the state wanted to, you know, kind of hang their hat on so they could argue he couldn't be there, he couldn't own the gun.
But he said once those gun charges and curfew charges were thrown out, he was feeling pretty good. He thinks the tears on the stand were real from Kyle Rittenhouse.
All I can say is when we prepared Kyle and we worked on his testimony, there were things we couldn't talk about in my office because it got too emotional and he couldn't handle it. He's in, you know, counseling for PTSD, so he doesn't sleep at night. Remorse, I think, manifests itself some other ways. I don't think he can ever walk out here and say that because of the situation. But I know Kyle Rittenhouse and I know what he feels.
And talked about how they had multiple mock jury trials, and the ones where Kyle testified, he acquitted himself very well. And all of their research pointed to the fact that Kyle should testify, and there were certain topics that they couldn't even talk about while they were prepping because Kyle became too emotional, which is evidence to the fact, in his opinion, that those tears were real. He also was pretty clear that everybody's asking Kyle for remorse and asking him to say sorry, and while he's not necessarily saying that, he believes that after talking to Kyle, he absolutely would not go out there and do what he did again, knowing all the repercussion and everything that happened.
I don't believe he does. I mean, you know, if he had to do it all over again and you said same thing is going to happen and life is going to be put in a living hell for a year and you're going to not know if you're going to be a free man, he would say, I wouldn't go. But we can't undo time.
So take that for what you will. He also doesn't think you're going to hear Kyle come out and say he's sorry for his actions because he was, in fact, defending himself from an evil man in Rosenbaum, what Richards called him, even though the jury wasn't able to hear how evil he was. We all know how evil he was, is what Richards said. And he also said that Kyle willingly gave over his iPhone, and his attorneys gave over the iPhone.
We were the individuals who released his cell phone, which couldn't be cracked by the FBI because we had nothing to hide.
And the FBI couldn't crack it because it was a new iPhone. So even though they had search warrants, Kyle's locks and stuff could have apparently locked this iPhone, but they let him do it. And they searched all of his search history, everything on his phone, and found no connection to white supremacy, which he thought was horrible for the politicians to bring into the fact. He thinks the jury felt and heard the truth that he was not. and that all that was just horrible, that people were saying it about Kyle and it just wasn't true. And other people were even saying that he is more liberally political than most right-wing conservatives. I don't know whether or not that's true, but the fact that they gave over this willingly proves they had nothing to hide. And he had no connection to white supremacist groups. And he thought that Kyle was a great client, great kid, and had a good head on his shoulders. He thought he was steered wrong in the beginning of the case by the first two lawyers that he took some shots at, doing some of those interviews and what happened with the bail money, but that generally thinks he's a good kid. Lastly, what did he think of the jury? And this is again, lastly, from that first interview right after the trial. And I think this was kind of commenting on the fact that, and this shows me that Richards is a good criminal defense lawyer and he knows what he's doing. His presentation may not be the sharpest all the time. He may not be the smoothest lawyer in the courtroom, but I think he's a good criminal defense lawyer because all of his interviews, he didn't say anything embarrassing. He didn't say anything that's going to be used against him in future cases. He made his client look good and only spoke highly about his client, didn't say anything negative about his client, but he also didn't kiss his client's butt and put him up on a pedestal where people are going to say, oh, you're fake. But when he talked about this jury, he did a good job of saying, when we saw them, they were intense. They took their time. We didn't hear about them fighting. We didn't hear about any misconduct. And they came back with a verdict after the longest time that I had ever seen in a criminal case that I've tried. So what does that do? Well, when some of the jurors came out and talked after the Chauvin case, we reacted to those interviews and people picked it apart and tried to say, oh, the jury didn't do what they should have done. Well, Richard said, if they just had a verdict in mind and already had their mind made up, well, they were amazing actors because none of us in the courtroom felt that. We all felt the tension and the labor it felt for them to come to this verdict, which shows they did their job and came to the right verdict, which to me is what you should want as a lawyer. That was the initial reaction interview that Richards had, but he also did a long podcast where they talked about strategy, similar to Binger's podcast that he did. They talked about strategy, why they did what they did, why they picked self-defense versus the militia defense, which the first lawyers had. They said they never believed in it. Kyle never believed in it. They talked about how they did some mock jury trials and how they were prepped for this way beforehand. He also talked about how he thinks defense lawyers have to be better lawyers than prosecutors, which I agree with him, because the prosecutors have all the leverage, all the cards on the table, and only have to try the cases they want to try, that they feel like they can win beyond a reasonable doubt. So they always have a leg up, so I agree with him there. Again, I thought he did a great job throughout these interviews personally, but there were some really interesting things said about the money. Kyle Rittenhouse has said in some interviews, and he talked, Mark Richards, about how they were raising all this money. Yet Kyle Rittenhouse sat in jail for 87 days. While maybe these first two lawyers were profiting off of his name and likeness and getting this money donated. Mark Richards talked about how he didn't get paid really until the trial started, then the money was flowing in. And his co-counsel paid similarly to him. But when asked if the consultants and the experts were getting paid, he said some of them got their first payments beforehand, but didn't get finished paying until the trial. And the lawyer interviewing Richard said, how much, I hear you talking about jury consultants and mock trials, how much did this cost? And he said upwards of 6 figures. And on other cases where he's done things like this, it's cost $250,000. So there were no discounts, it seems, for the publicity. But 6 figures worth of costs for consultants, not legal fees. We didn't get to hear exactly what the legal fees were, but they were paid out of these funds of money that were raised for Kyle. And I think Woods or Pierce, I actually can't remember, one of the prior two lawyers was still off the case as a lawyer because they wanted to do interviews, they wanted to raise money, but they were out there raising money for this cost of defense and for some of these causes associated with Rittenhouse's defense. But Richards and his co-counsel were there to represent Kyle, to be criminal defense lawyers, to build a rapport, to build a defense, to build a strategy, and that's what they did, and that's what they were successful in doing. And he also felt it was important for those other lawyers to get off. They were not attorneys of record because Schroeder would not have liked them out there on Tucker Carlson, doing interviews, being all over the media, and continuing to raise money for these cases. And if you're wondering how that $2 million of bail came, who paid it exactly? Who signed for it? Well, it seems like we might find out because Richard said these lawyers are still calling him, bothering him about that money. Everybody wants a piece of that money. Everybody is laying stake to their claim for that money. and they are saying it is theirs, and it sounds like through some litigation, we may find out exactly who paid what of that $2 million. Now, if it settles outside of court and that money is released without us ever hearing about it, some concessions were made and people didn't want us to know where that money came from. But it seems like right now, a lot of people are saying they have a right to that $2 million. And we'll see what exactly happens, because to me, that's always an interesting factor in these cases. But Richards and his team seemed like they had a plan, they had a strategy, they put it on, it was successful, they prepped it, they practiced it, and they did their best. He had a binder that was this thick of what happened from all those practice mock jury trials and everybody's input of what they needed to do. And he felt like reviewing that helped them put a strategy together in this case that won. And that's not uncommon. The lawyer doing the interview said he never did any mock trials, and some old school criminal defense lawyers swear against it, but others swear by it. I don't think there's a one size fits all when you're trying a case like this to you have to do mock jury trials, or you can't do it, or it's going to steer you the wrong way. But I thought it was kind of good to see two sides, a lawyer that never does it and a lawyer that did it in the biggest case of his life, which he admitted to. This was the biggest case of his life, and it worked. They pulled some strategies from it, and they got the verdict that they felt was just from their client. So hopefully you guys enjoyed this. Hopefully you hit the like button if you haven't already, and subscribe to our podcast. Share it with your friends if you're interested in it. If there's anybody else in this case that you want us to react to an interview we haven't seen yet, let me know. Send me some interviews and we will look into doing reaction videos. But for now, that's all we've got. Until next time, thanks for being with us. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.